We've got an episode. Everybody should watch the first one because you and Yuvika did a great job talking about the original stuff that came out with Weinstein. But there's some other questions that I think we need to dive a little deeper into the topic. And one of the points
it's not about Weinstein.
Well, this is the thing.
It's about every other accused in North America.
So people look at this case as if it's about should Harvey Weinstein be found, innocent or be, acquitted because of technicalities or something. The reality is this decision is so important because his rights are your rights. And it doesn't matter if you like Harvey Weinstein or not. These decisions are so important to uphold the rights of every accused person. And that's why it's important to really look at this case, not in terms of whether or not it's about Harvey Weinstein, but look at it in terms of whether or not it's correct in upholding the principles of law and your right to a fair trial.
Right on. So, under our system of justice, the accused has a right to be held to account only for the crime charged. Thus, allegations of prior bad acts may be admitted against them for the sole purpose of establishing their propensity for criminality. I tried to inject a bit of British.
It kind of dropped off at the end, though.
Well, no, that's totally fine because we come from the British system, which is a little bit different than the American system.
I know.
Yeah, but this is really important, and this is something you spoke about before.
Yes.
An accused has a right to be held accountable only for the crime charged. Allegations of other bad acts may be admitted against them for purposes that would be relevant in Canada and other Commonwealth jurisdictions under a similar act laws where there is a significant relevance as to the modus operandi of the accused. And as the United States court said, cannot be for the sole purpose of establishing their propensity for criminality. And let's translate.
That's what this is totally about.
And let's translate the Canadian language.
This is totally about basically swamping the jury or the trier fact, if you were judge alone, swamping them with similar allegations that they're not even charged with to say, oh, obviously he did it because, how could this many people be lying?
Well, that's essentially right. So the whole point of this is establishing their propensity for criminality. It's their propensity for committing these types of offenses.
No, it goes beyond that. Did you see what they?
Well, I did. Go more. I can't let go of this decision because it's so important.
And we are going to get to some
for a
new
national and international level.
We are, but we covered this in the last episode. But it's important to hear this.
It's important just for people who didn't see that.
This is the kind of stuff that went in. The allegation that he threatened to cut off a colleague's genitals with gardening shears.
Well, this is why I say, guys, and I'm sorry, you're f***ing nuts in the United States.
Wait, it goes on.
No wonder he didn't testify.
Well, that's what we said. Screamed and cursed at a hotel restaurant staffer after they told him the kitchen was closed.
I do that now.
I know.
But, okay, so this is different than the similar fact from other women who are saying things.
This is broader.
This is just bad character.
Right. So this is stop, pause, question mark. Okay, let's delineate between the United States insanity and Canada. I say this a million times. Canada, okay? You can admit similar act evidence about other similar acts of a sexual nature highly, highly similar to the act in question. Right? A striking similarity to establish a modus operandi. Otherwise, not admissible. Bad character evidence can be admitted for very limited purposes.
Very narrow.
In the United States, it's like a vomitous amount of evidence. Who knows for what?
All the skeletons in your closet.
This is a great decision.
But primarily what we see bad character evidence for is in a long-term relationship, they want to put in these other alleged threatening behaviors to say why she wouldn't have left.
Course of control.
Why the person didn't leave the relationship earlier.
To explain certain things that may be relevant as to why somebody disclosed, why they stayed in a relationship, none of which often we question. But there are specific grounded areas of relevance. The United States is like much broader. But this is really important because in Canada, it was broader before. Now we're really condensing the admissibility of this type of prior bad acts and similar act evidence is all the same thing.
So before we move on, though, to other things that are even
Don't
more
move
current.
on. Take your time. This is really good. I love this. I want to have 10 episodes on
Why is it important to not allow this evidence?
Because it's bogus. It's just basically allowing a jury or a judge to convict an individual on other untried allegations of bad character evidence.
That's what Loftus said.
I didn't
Loftus
leave a tip. I didn't leave a tip. I yelled at a coffee barista. I yelled at the parking attendant. Like, what the f***? And in Canada, we need to be careful about bad character evidence. And we have this in cases now we're doing. We're putting sex back in the box, right? We spoke about this before. Because there's so much bad character evidence in a divorce.
You look confused.
There's so much bad character evidence because it's a divorce. And then after the separation, it's like, he's like yelling at me or messaging me about the children and this and that. They want to get all that type
They want
of
to
shit.
muddy the waters
It's
by
not
making
relevant.
it about a bigger issue.
Right. This is very important.
A crime is what? A crime is a specific allegation that happened on a specific time frame. Not always. Sometimes there's a big time frame. But it's about a specific allegation. You're only on trial for that allegation. You're not on trial for
threatening to cut off your
Yelling,
bad
threatening, bad conduct, or what they want to do in Canada is create coercive control.
what do we say in the comments? Because we do actually listen to the comments and respond to them when we can attend. You can't be charged criminally with being an asshole. Being an asshole is not illegal.
Maybe a character defect, but
No, but it's not
it's
illegal.
not illegal.
It's not evidence.
exactly. Well, that's why everyone
And
was
that's
going, why
essentially what
didn't
people wanna
Harvey
do.
testify?
So,
Well, this
but
is why
God
he
bless,
didn't
God bless
testify.
this Court of Appeal.
Well, no, that's an important point too that you're
is.
making. So what they found, one of the things that they primarily found is that he was deprived his right to testify because
of this crap.
the jeopardy of testifying was so intensified by the decision that he could be cross-examined on anything his entire life.
Uh-oh, timeout signal.
Can somebody explain this slowly for our viewers? Because the United States is insane. I love you, U.S. I love you. But your law is insane.
Well,
Explain
they got
this.
it right
Stop.
this time,
Slowly
though.
explain this.
They got it right this
The
time.
bad character evidence was unbridled
Totally.
at trial.
Totally. Broad, or as the Court of Appeal said, a broad range of uncharged bad acts. Broad.
So describe what this decision-making
irrelevant-
process would be
The
like.
Court of Appeal found
when you decide
on
to wait-
irrelevant, prejudicial, and untested allegations of prior bad acts.
Right.
And we're not just talking about sexual bad acts. No. Everything. That's insane.
As a defense lawyer, talking to your client about whether or not they're going to testify, and you have a decision like this,
There wasn't much of
where
a
they
decision
said,
to make.
where they said, he can be cross-examined on this. What would that conversation look like?
So I'll be honest. Let's talk about this. Excellent point. Because we say you can't win these cases unless we call a client. So I would say, look,
It's a
Harvey.
he said, she said.
I'd say, Harvey,
there has to be a he
Harvey,
said.
you're going to be cross-examined on every bad thing you ever did in your life. But you know what? You still got to testify. And here's what you got to focus on. The allegation. So when they ask you about all this you go, I don't remember. I don't know if I tipped that person. I don't know if I didn't. I don't know if I did this or that. So how do you have this discussion? I believe in perpetuity. I've only done with us, 3,000 sexual assault
I
defenses?
thought it was 3
I
million.
mean, some minor amount, okay?
Some minor amount.
And in that minor amount, I've never called a client maybe in 10% of the cases, okay?
Even that's high.
In the United
It
States,
was like, that was a weird phrasing. I've never called a client, maybe sometimes. So you always call your
I always
client.
call my client.
Always call your
10%
client, except
maybe,
for maybe
of those 3,000
That
cases,
is-
maybe I never called them.
That's a lot of grade 9.
But in the United States,
I just hate double
I get
negatives.
the lawyers. I get the lawyer's perspective. Like, if I put my client in the stand, they're facing bad character evidence, like not being a parking attendant, not cheating in marbles, all that.
Well, the most important thing, there's no he said, and a he said,
Do
she
they still
said.
play marbles?
There's gotta be a he said. Otherwise, it's there's only Crown evidence.
So what? But you raised the question, which is a great question. What was that conversation like? What would it be like? I would say, look, I think you should testify. Because I think on this point of this allegation, which is before the court, you have good evidence to refute her allegation. All that other stuff you'll have to deal with, but I don't think that goes to the core of the evidence. And the Court of Appeal raised a good point here. He couldn't testify because of this adverse ruling, allowing all this bullshit in. And this is a cautionary tale across the world. You can't let in evidence of bad character, period, unless it is highly specific and relevant.
And
grounded.
erase for a moment that it's Harvey Weinstein, and whatever you think about Harvey Weinstein, imagine what this means for
We're not
anybody.
defending him.
I know.
No.
We're not saying he's a good guy or a bad guy. We're talking about the principles.
So, what you're saying though brought up another point for me. If your
Good for his
client,
lawyers.
if your client is testifying, and then all of a sudden they have all this bad character evidence coming at them, do you object? How do you object? How many times can you object?
Sorry, here or in the United States?
In general, what do you think
So
is appropriate?
I can't speak to the U.S.
No, this was
and-
a pre-trial. This was determined at a pre-trial motion.
Yeah, and his lawyers did an excellent job. And, Arthur,
If they go beyond
I hope I pronounce it, Adala, who
Because we had a client. We
who
had a
I've
client,
seen a number of times.
When you objected to a line of cross-examination, they just went, because this was a retrial, and they was like, "Oh my God, that was the best word I've ever heard," because his previous lawyer never objected to anything. But at the same time, you don't want to object too much because it looks like you're trying to interfere, right?
Right, but this was a pretrial motion, which we would do in another case. So, there are pretrial motions. Pretrial motions like this defense lawyer did in the Harvey Weinstein case originally to challenge what would be inappropriate evidence to bring before the court. Okay? Right. And he objected to all this. And on the appeal, he did an excellent job setting all this out. Arthur Adala, I hope I'm pronouncing that correctly, Aidala. He's excellent. His excellent, dresses extremely well. I've seen him on CNN. Almost as good as my dressing. Love the guy.
Almost.
But his points are accurate, and it's apposite for us as well. Now, let's distill this down for a moment. What is the relevance of this?
So I'm doing this little hair flip.
Okay, but what's the relevance? Let's stop for a second. Why the is any of this relevant?
Which part?
Anything other than the complainant's evidence. Why?
It's not.
Let's just talk about this. As normal human beings, for a moment, let's just have a discussion.
Why is this?
Diana, you're a
I'm sorry, I got
journalist.
lost in this because the word "this" was a little bit too
Opposite.
The complainant makes an allegation, and the Crown or the prosecution in the United States wants to call evidence of other uncharged acts.
Why is the
that
other
relevant?
evidence relevant? Right. So
What?
I don't see how it is because
I agree.
if it was relevant, he should be charged with the allegations
Right.
from that complainant. Why did they not charge him? Right? Why do you call a witness making allegations, but you didn't think those allegations were good enough to charge for? Right?
Well,
And
I don't
understand
even know
sometimes
that.
they're timed out.
Let's assume we don't know why it wasn't charged, but you want to call it in a case. We assume it's not charged, okay?
Right.
And never went to trial. So what's the relevance? There's no relevance unless somebody has a specific. If it goes to fucking identity, this is my point. Okay, stop. Everybody, listen to me. Okay, modus operandi
think
is
we
really
have to.
only relevant to identity.
I have a relevant question.
Relevant?
It's very relevant.
okay, pause.
Why can
So-
you not bring evidence that a complainant made a false allegation against somebody else?
That's an excellent point.
Thank you.
You can't.
So you can have a complainant who is accusing somebody else, and they were found to have made a false complaint, previously.
hold on.
You're not allowed, or
What does that mean? Okay, stop. So, if a complainant on a previous occasion has been found by a court of law to have made a false allegation, you can bring that forward.
Right.
If they have been demonstrably found to have made a false allegation, you can do that.
Or charged.
But
if they just
demonstrably
retract,
found. But has to be recantation or found in a court of law. Anything short of that, you can't bring in.
but it also has to be very similar to some extent.
No,
like I've
you-
seen,
you-
I've
no,
seen
you
other
can do
cases
that for credibility.
Where they, well,
No.
okay, yeah, you're correct. I've seen other cases where they alleged extremely similar acts against a different person, but they weren't allowed to use that evidence in their trial,
Because
even though the acts were extremely similar.
Because it wasn't proven to be demonstrably false.
Yeah, and because it didn't go anywhere and there's nothing. But the alleged acts were almost precisely
Right.
the same.
Well, that's like
but
my
it's
London case that I had,
so how's that different than these other people he's not charged with?
No,
who are making,
no. So let's be fair. So if a complainant can be established to have made a false allegation against someone else, and it either resulted in a withdrawal of the charge based upon demonstrably provable evidence, or there was a recantation, you can call that evidence. If, however, there was an allegation made before, but it went nowhere, there's no merits to do it. So flip that over.
That's what they were bringing into Weinstein's case. He wasn't charged
Right. What you're saying is flipping that over. There's allegations of sexual misconduct that would never made it to any judicious review or adjudication. Right. Yeah. And in Canada, the same thing.
You can't bring the reverse in.
I agree. I mean, in this case,
would we like that? So here's a question for all these,
but it would
all
be
these
open,
people saying this is an injustice.
It would be open to the defense in any case, Canada or the United States, if the similar act evidence is in, you're facing multiple counts, whether it's on the indictment or not. We would challenge all those counts, right?
Right.
So Diana, what we would do is our client would testify and say, I didn't do it to Jane or Miley or Cyrus or whatever, and we would work with the client on his narrative against all of them. But he couldn't, because he would be facing in the United States, an avalanche of bad character evidence, which is unheard of in other jurisdictions. It's insane what they have in the United States. This Court of Appeal brought it back.
Here, read what they look at what the 3 uncharged witnesses would have said at trial.
You do it. You don't talk.
Okay, well, in the meantime,
hang on, time out. Let him talk. He doesn't talk that much. He's got a really nice tie today.
That's true. You just sit there and look pretty
and intelligent on occasion. So these are the 3 uncharged witnesses. All claimed he made unwanted sexual advances towards them. Witness 1 stated that she met the defendant in 2004 at a Manhattan nightclub while she was working as an actor, and the defendant said he could help her career.
Sounds like a bad movie.
Yeah, I know.
No, but listen to this for a second.
Sometime in 2004, 2005, she met defendant in a hotel room for a networking event. He led her to the bedroom, where he suddenly put his hand up her skirt and tried to put his hand inside her vagina and apologized when she pulled away. That's just one example of the witness that went in.
Right.
So these are uncharged allegations of sexual misconduct.
So can I?
It goes from the mundane
to the insane.
To the insane.
I like that expression.
Can I just cut away a little bit to a response to this? His appeal being granted by.
The law thing.
Yeah, I love that. Go.
This is a comment by a woman who's got special expertise in the knowledge of this area, because
almost a master's.
She's an actor, Mariska Hargitay.
She actress anymore or no?
I love her on that show.
Once an actress, always an actor.
I know, but I loved her on that show.
Always an actor.
Yeah,
but
it's not real life.
But she knows, because she worked on Law and Order Special Victims.
SUV.
He just loves to say that.
So because she's an actor on a show about law, apparently she's got important opinions about law.
Almost an expert, I'd say.
And I'm sad because, look, she may be predisposed to stories and lines that are based upon real life issues. Well, that's what they say. And she's impacted by that. I get it. But this should never, ever, ever be an area of commentary or any seriousness in the public media.
It can't be substituted for a legal opinion.
I agree.
Just because she worked on a show that has to do with law. I mean, bless her, she's doing advocacy work, and I'm sure what she's doing is important. But she said...
Yeah, I don't blame her for doing that.
She said, I want to talk today about reversing convictions. It is impossible to reverse my conviction that survivors matter. That's what happened. That what happened to us matters, and that our society must respond to survivors more compassionately, more holistically, with a deeper, more nuanced understanding of what healing means. And then later in the speech, she says, I do want to say something about the overturned Harvey Weinstein conviction, specifically about the reason it was overturned. Too many women's voices. Too many women were allowed to speak.
Uh-oh.
She continued, risky to let women speak. You're damn right it is. Too many of you speaking brings change. Okay, so I want to say this.
This is the red button for Joe. Go, Joe.
Go.
Love her as an actress or actor.
Or both.
And I love her passion. But she's f***ing wrong. Okay, this is not about survivors. This is a court of law where we can't perverse the trial process.
I think he meant to say pervert.
I like perverse, actually.
Perverse the process?
No, perverse.
Okay. I'm good with that word. They're similar.
It is perverse.
A survivor presumes guilt. I never want to hear that ever again. Get that out of your lexicon. You only have a person who is a victim after a trial convicts an individual on appropriate evidence beyond a reasonable doubt, period. And they're not f***ing survivors. They're victims. I get that. Okay? Second, I'm so going to get a hate mail because of this.
Well, I can
It is not about too many women's voices. It's not. It's about impermissible evidence.
Right, I know.
Leading to a wrongful conviction. Not just in Harvey Weinstein. It's not about him. Love him, hate him, whether he's a predator or not. It's not about him. It's about general principles across the road for other people who can be accused and to prevent against wrongful convictions. It's not about that. Women's voices are not silenced. Women can speak out. True victims can speak out.
Women talk
Just
3
do
times more
this
than men.
in a permissible way that's admissible in trial.
Right. And so here's a point I want to
100 people who come forward doesn't mean that person's convicted because it's 99 people of uncharged allegations. It gets to be a point where it's wrong.
What this calls for
It's not based in evidence.
is
Calls for
mob
something.
justice. It's saying we have tons of people who want a certain outcome. Therefore, don't silence us. Your legal system doesn't matter anything to us because we have tons of people who want this person convicted.
all over again.
That is mob justice. That is why we have a legal system to prevent vigilante justice, to prevent mob justice.
Right,
So
and
this
here's the
exact
problem.
point,
This
this
is why-
exact point
this is
she's
why-
making is why what you do is important.
We do it. We're a team. Here's the problem, and I understand her issue. I get it.
Yeah.
Harvey Weinstein is a flashpoint, right? Mm-hmm. It's the wrong caricature for us to talk about this issue. I get that.
It is a caricature now.
It
Actually.
is. But, that's all we're talking about. It's not Harvey Weinstein. It's about an accused, male or female.
Yeah.
It's about an accused and bringing forth evidence of uncharged, untested allegations. And because you have 1, 2, 3, 4, 5, 10, 20 other people testifying doesn't make the actual substantive charge more or less likely to have committed or to be believable, to be true.
Yeah.
And it will distract from the truth-finding process. It's highly prejudicial. And how do you defend against that?
This push to allow this type of evidence, to me, is a push to undermine the principles, the hard-won principles of our legal system. It's taken us hundreds of years to stop torturing people into confessions and stuff like that. You know what I mean? Like, we've taken a long time to perfect this. Cross-examination is one of the most important staples of our current system. And these other rules about admissible evidence and other, bringing in this mob of people who want to say bad character things. Well, what's the difference than being in a courtroom or being on social media, right?
And can I just take this a step back? And
Except for the courtroom can
let's
send you
all
to
calm
jail.
down. Let's all calm down. Let's just take this back for a second,
Still
okay?
pretty calm.
Okay, just let me deal with this because we all have a particular concern about similar act evidence in Canada, now evidence in the United States with their insane process. Okay, so Special Victims Unit star Mariska Haggerty blasts Harvey Weinstein's overturned conviction, okay? And she's talking about silencing the voices of other women who are abused by Harvey Weinstein. Okay, I understand her anger. Let's take a break. The complainant in the Harvey Weinstein case, why can't she just testify on her own and be believed? Pause.
Apparently, she needs a best friend to go to the bathroom with her.
You didn't pause. She said pause.
So just pause. Pause.
You gotta do one steam.
What's wrong with her evidence? I'm not judging the case, but we talked about this.
That was a pretty funny answer, though.
I know, but we may need to edit that one out.
No.
No, but honestly, stop. Calm.
Pause, Diana.
She can testify. She did testify.
She did testify.
She testified in a very compelling manner.
Still making myself laugh over the comment.
What word is making you?
That was really
compelling.
I
or
was
the
just like,
seriousness?
she needs a friend to go to the bathroom. Come on.
Let's assume the prosecution just called the main complainant. What's the problem?
None
As in 99%
of our
we have.
cases that we do. Yeah.
Yeah, a complainant is a very compelling witness.
Yes.
She gave compelling evidence. There's nothing to say that on the evidence of the complainant, Mr. Weinstein or any accused could not be convicted. A conviction can be founded. A conviction can be founded on the evidence of a complainant alone.
There's a lot of protections.
Why it up?
There's a lot of protections put in place for complainants who testify. They can have screens. They can go CCTV. They can have support dogs. They can
She
do all
didn't even
kinds of
need that.
things.
This witness, who happened to be Canadian, this complainant happened to be Canadian, stood there, took an oath, sat down, testified in open court. Good for her.
Yeah. What else do you want?
Cross-examine her as much as you want. Have him testify. Jury will decide.
Okay,
What's the problem with that?
Here's something that crossed my mind.
But what's the problem with that? Why do you need the circus? Why do you need the circus?
If you're so convinced that Harvey Weinstein was absolutely guilty, why do you need to break the rules? Why don't you just do it straight?
Well, that's what we're talking about. But
I know, but that's
not-
another way of looking at it, because like there was another. Excuse me,
wait. It wasn't a
It was a case in Canada where they had blood in the truck and everything, and yet they went over and they brought in all this evidence that wasn't necessary, and so it was appealed because there's like it was a slam dunk case. If this was a slam dunk case, why did they have to go and do all this stuff?
well, that we're second guessing prosecution. But I know how it is in the United States, and I know how it is when you got a Harvey Weinstein as an accused.
And also,
Look at
prosecutors
what's
get
going on to
elected.
Trump right now. Stormy Daniels testifying about the salacious details of a f***ing sex encounter to complete the narrative about why there was a payoff and it was labeled as a legal expense and therefore it's a f***ing, I don't know what, a felony. Give me a f***ing break. This is what the United States does. I'm sorry. All the viewers from the U.S., you may hate me. You don't need to do this shit. There's no measure. There's no elegance to this. I watched other cases in the United States, I'm sorry, where they literally litigate the case before it gets to trial in the media.
I know. And then how do you find a fair jury?
It's insane. You don't need to do this.
Right.
I agree absolutely with the Court of Appeals decision in the Weinstein case. This complainant is a strong, capable person to testify on her own merits and say, I was sexually assaulted by Harvey Weinstein. Here's my evidence. Leave it at that. Don't put in all this other bullshit because you feel the desire to give other women voices who their charges never made it to the day of court. That's life. That's the way it is. Done. Just deal with your evidence in front of you. You want to prosecute Donald Trump, the former president? Fine. Really, did you need to have her testify about all the salacious aspects of a sexual encounter? It's just f***ing garbage.
Well, so
It's wrong.
Just to close this off about Weinstein,
That's why I love our Canadian system.
Weinstein's still
we
in jail.
We don't do it like this.
right? Weinstein's still in
We
jail.
have a great justice system here in Canada.
Why is Weinstein still in jail?
California.
Because he's convicted for 16 years, a case in California.
But I bet you they called evidence in that case.
This is the thing. They called evidence in
rules
that case
there.
that he was convicted in another state of sexual assault. Now that's been overturned, and he gets a retrial. They have a serious case.
So
for an appeal in
what's the
California.
takeaway from this? Do what Canada does.
You got a strong case. Bring your case proper. Don't stack it. Don't bring in evidence that's inadmissible. Don't try and subvert the system in order to get a conviction. A prosecutor's job is to seek the truth, not to seek conviction.
That's why I love our system in Canada.
Minister of Justice.
Same thing in the States, though.
No. The United States is about headlines. You've got elected district attorneys. You've got politics. You've got everything involved, and that's everything that's wrong with
People
the
get
U.S.
elected
system.
on a campaign to get a certain person
Tough on
convicted.
crime. Yeah, of course.
So that is, but they still have, because
That's where lawfare comes up.
quote.
Right.
There's a great quote from the U.S. A judge said the most powerful person in the justice system is not the judge, it's the prosecutor. They decide who to prosecute. They decide how to prosecute.
That's right.
Okay, so you're going to take me back 28 years. I met a U.S. prosecutor in Florida when I was about 27, 28 years of age. A long time ago. And he was an amazing guy. And he said to me, you know what? My ability to prosecute somebody and make the decision to prosecute, because in the United States, the prosecutor makes a decision whether to bring charges, unlike Canada. He said, I understand how powerful of a decision this is, how much of a judicious decision this is, and how it can impact somebody's life. He said that to me. He wasn't intoxicated. We were having Lux and cream cheese. He happened to be Jewish. We were, God bless them. And, you know, you protests. But anyways, you know, and he was right. And I loved what he said to me. And it has never left my mind. And he said to me that he took his power very, very, very seriously.
Yes, they should.
But everything has been politicized and co-opted, the woke left, all sorts of agendas, and it's disgusting. And that's why I love Canada. We are still subject to these ills, but we do a very good job of walking down the middle.
Walking the line.
We'll end it there because I don't want to get political.
Oh, really?
What
No,
state
but really,
Canada's in?
it's very
I'm not
important.
feeling so positive.
It's very
I'll tell you
important.
the
There
truth.
has been in Canada. So when you look at bad character evidence and similar act evidence, you're looking at RV, ZCW,
ZWC.
okay, and
MRS. Yeah.
and Handy. You'll see that there's a good tightening of how we deal about this, and it's a very focused approach to how we admit this evidence. Very good law. And I think it's extremely instrumental, and there has to be a real distinct purpose for it. Yeah. We do a very good job of this, and we've stated this. We talk about all sorts of complaints about false allegations and other things, but it really is a good process here.
Yeah. Well, the one thing the state still has over with us is if you get acquitted, you can't be retried.
Got a clink.
Yeah. No, I agree with that, and they have that right. And what's the other thing that they have right? Picking a jury.
Yeah.
Right? We can't pick a jury. Thank you, Justin. Thank you, Justin. Thank you, Justin. We can't pick a jury in this country. Thank you, just the first 12 or 13, for your diversity initiative. You. Good night.